Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, January 7th. Hope you guys all had a restful couple of weeks off. We did not because we were poring over your briefs. And since we pored over your briefs during this period, we are fully familiar with your arguments. So when I call the calendar, please ask for the time that you actually need to get out the salient points of your arguments, okay? People v. Benjamin Lohman. That matter is submitted. Gins v. Gins. Did you wish any time on rebuttal? Did you wish any?
I'd like to reserve 2 minutes for.
5 and 2 and 5. Matter of Christian is submitted. Herlick v. Laura. 424. LNV Corporation v. Cordero. Did you wish any time on rebuttal? There is no appellant. Okay, 4 minutes. Yang v. Knights Genesis Group. Five two five. Morales v. New York City Housing Authority. 525 and 5. People v. Joseph Montesquieu. That matter is submitted. Alonzo v. RP 1185 LLC. 424. Barini v. Inform Studios. 3 and 2. I'm sorry? You have a cross appeal? 323. People v. Corey Key.
For Corey, 5 and 2.
Rachmaninoff v. the Board of Standards and Appeals.
I'll rest on my brief, but if you have any questions, I'm happy to answer.
Thank you. The matter is submitted. Slifka v. Paul Weiss. 626. People v. Angel Benedict. That matter is submitted. Watson v. Roanoke Island. I do not see a respondent. Is there a respondent on this matter? There's no respondent. 3 minutes. McDonald versus the City of New York. Moldavon, versus the City of New York. Matter is submitted. Thank you. People v. Pedro Rodriguez. That matter is submitted. Peck v. Milbank, LLP. 525. First matter for argument is Gins v. Gins.
Good afternoon, Justice.
Good afternoon.
There are 3 reasons the motion court's order here should be overturned. I will go through each. The first is the language of the postnuptial agreement.
Seemed pretty clear in terms of what was to be distributed and how it was to be distributed. It was his portion of any inheritance. Is that correct? Oh, why don't you step over to the mic so everyone can hear you? Thank you.
I believe that is the case, Your Honor, until he turns 70 years old, at which point his obligation changes. While his obligation before that time was to split his inheritance 50-50 with his ex-wife, if he turns 70 and has not yet received that inheritance.
And he is unable to continue his Mass Mutual term life
Yes.
insurance.
Exactly, yes. If those two conditions precedent are met, then his obligation changes. He must then name his ex-wife in his own will and bequeath her 30% of his own estate. This is the superseding requirement if he has not yet received his inheritance at the time he turns 70 years old. Now, the motion court did not deal with this provision of the agreement at all. It was not addressed or mentioned in the court's order, even though it had been briefed fully before the court. I believe this is a fairly clear agreement in this circumstance. I think that he indisputably did have an obligation to provide 50% of his his inheritance to the respondent, his ex-wife, until if, at the time he turned 70, two things occurred. He had not yet received his inheritance, and he was unable to continue the insurance policy.
But he received his inheritance.
Only after he turned 70 years old. His mother died at the time he was 71 years old. The agreement says...
The if applies to whether, in fact, he had received any inheritance, not if he turned 70.
Well, the language of the agreement specifies that at the age of 70 is when the obligation modifies. I have the language right here. Let me take a look at it.
And at the age of 70, he has not yet received his inheritance, and he is unable to continue his Mass Mutual term life insurance.
So if at 70 and he has not received his inheritance, but in this case, he did receive his inheritance.
No, at the age of 70, he had not received his inheritance. That was not disputed before the trial court. His mother did not pass until he was 71 years old.
Did the father pass prior to his turning 70 years old?
Yes, but he did not receive anything from that estate.
So when the father died, the monies from the father's estate went to whom?
The mother.
And would he not have an interest in those monies?
He did not have an interest in those monies at the time that his father died. He only received an interest, presumably, in those monies, unless his mother spent all of them, after his mother passed away. He received nothing after his father died.
Wasn't the intent of the agreement that he would receive monies from the death of his parents, meaning the mother as well as the father?
I'm not sure if the intent in regards to which parent or both parents he received inheritance from is clear. I believe the agreement just refers to inheritance.
Full inheritance was defined as one half of the estate of his parents as divided between he and his brother.
Yeah.
So when the father died, he would have an interest in whatever monies the father left, right?
But the father did not leave anything to him, would be my point. The father did not leave Robert or his brother any money. All of the money from his father passed to the mother. So only upon his mother's passing did he receive any funds.
But when we talk about full inheritance from the estate of his parents in terms of the agreement, is it not also referring to any monies which the father had?
I suppose it could have been had his father deigned to will him those monies upon his father's death. If his father had said, here you go, son, here's $100,000, I actually agree that would have been covered under this. But his father did not do that. His father instead said, 100% of my funds will go to my loving wife. Then his mother, Robert's mother, the appellant's mother, left the remainder of her funds to him upon her death.
But that really doesn't have any consequence in terms of the agreement between the parties here, because the agreement between the parties here was that she was going to receive a portion, 50% of any inheritance.
I agree with you.
So whatever the father did in terms of his estate really has no consequence in terms of the understanding of the wife as to her percentage.
I agree. I think we're saying the same thing. I agree that the wife anticipated, until and unless certain conditions precedent were met, receiving 50% of any of the inheritance that her ex-husband received. He did not receive any inheritance from his father. He received inheritance only from his mother after the age of 70, which is when the obligation of his changes from having to split 50%. It's a bit of a complicated agreement, from having to split 50% of his inheritance to instead naming his ex-wife in his own will. 30% of his own estate would then be willed to his ex-wife.
So, counsel, you're conceding that he did, in fact, receive inheritance and it wasn't as part of a trust, right? Based on your arguments here, correct?
No, I'm not conceding that. I'm using those words just for the sake of argument, but the second basis, this is unrelated, I would say, to the first argument. But the second argument that we made is that, in fact, he did not technically receive an inheritance as that term is defined in the parties' postnuptial agreement. The parties' postnuptial agreement defines inheritance as, and I'll quote it, one half of the estate of the appellant's parents as divided between Robert and his brother. The appellant received funds after the death of his mother, not after his father, but after the death of his mother. He received, by operation of law, the remainder of a trust that had been created in his mother's lifetime.
He received that as part of his inheritance from her estate, correct?
There was no estate, actually. So I would argue that an inheritance and an estate, yes.
To my colleague's point, there were monies that had been placed in trust after the father died and prior to the mother's death. And he did receive proceeds from that trust after the father died, prior to the mother's death.
No, that's not correct. He did not receive proceeds from the trust after his father died. He only received proceeds from the trust after his mother died. He received nothing from his father.
Did assets of the mother and father fund the trust?
I don't know about the father. There was no allegations or discovery on that. I truly don't know what happened to the father's funds, if he had any funds, at the time of his death.
What happened to the mother's funds, assets and funds or otherwise, at the time of her death?
All in the trust. Those were in the trust. I do not know when she placed them in the trust. Again, that was not something that was argued or done discovery over at the lower court. But all of the mother's funds, I will fully agree, were placed in that trust, which he received after her death.
Thank you.
There are no other questions on
You
it.
have time.
Oh, okay. Sorry.
Okay.
The final argument that we
Your
made.
rebuttal is after your friend makes his arguments.
Understood. Thank you. The final argument we.
No, so he goes next.
Oh, I'm sorry.
And then, that's okay.
Thank you, Your Honor.
I know, it's a new year. Yes.
May it please the court, my name is Jay Breakstone. I represent QQ Cosigins.
So, counsel, I thought that based upon the record, that he did in fact receive certain distributions from the trust prior to the mother's, after the father's death, but prior to the mother's death.
I see a ton of checks in the record, in fact.
And they came from a trust, right? Is that correct?
They didn't come out of the air.
And the trust was something that had been set up by either the father and the mother, or simply the father.
I think you would be correct if you said the father and the mother.
So therefore, those monies would have constituted an inheritance, because but for the father's death, right, those monies would not flow to him.
That's correct. I think what we have here, Your Honors, is a and you know the Court of Appeals spoke to this very early, back in, oh goodness gracious. And this is not cited in my brief, and I apologize for that. But it's actually this court, not the First Department. But in a case called Silber v. Silber, which deals with everything else in the world, but it talks about these terms like inheritance. And it says the definition of an estate was drafted, and we don't muddle the meaning of that. In other words, there is a broad definition to all these terms. What happened here, ideally, and what I want to do in my short period of time that I have, is just talk about the last 2 points of the appellant's brief, the concept that this was unconscionable, this agreement. Boy, oh boy, pretty good for unconscionable
Before you go
agreement.
to the unconscionability of it, can you speak to the provision that your adversary spoke to regarding that he didn't receive any inheritance before he was 70?
Well, the fact of the matter is, of course, he did. And that's why I talk about terms of inheritance.
So those are the distributions from the trust.
They're from the trust. So you begin to wonder why, you see, the triggering point of this agreement, and the point that the appellant loves and adores, but throws out the rest of the agreement, is that when this gentleman said he no longer could pay his life insurance premiums, that triggered in their mind the ability then to go down to the 30%, and at the end at his death, and if it's there, fine, and if it's not, well, that's fine too. She'll have a first charge against the estate. Absolutely nonsensical when you view it the way that
So
appellant
do you
views
agree
it.
with your friend in terms of the provision as to 70, that if in fact he had not received any monies by the time he turned 70, then under the terms of the agreement, no monies would be due to the wife?
No, I don't agree for a number of reasons. The first reason that I don't agree is that the concept that an unsubstantiated statement, I can't pay the life insurance premium, is just, in the context of this agreement, which the appellant thinks is unconscionable and against him, and he didn't have the ability of a lawyer in this agreement, he had it in other agreements.
Well, apparently he refused. I think he
He refused, yes, he could have
But he
had it.
also stated that the wife was harassing him. I think his brother or somebody else also attested to the fact that she was constantly harassing him and trying to convince him to sign the agreement, and he just felt that he had nothing. He had to do it because just to get her off his back.
Well, I don't think I've ever seen a matrimonial where I didn't see those allegations, a litigated matrimonial.
Every matrimonial case has some
I
harassment.
said litigated matrimonial.
But the
Doesn't have
provision that
those.
we're referring to, again, Section B, and at the age of 70, he has not yet received his inheritance, and he is unable to continue his Mass Mutual life insurance policy. So again, under this agreement, your friend reads it that if at 70 he hasn't received his inheritance, then no monies go to the wife.
Two things necessary. Even if Your Honor was going to say, let's assume that he didn't receive his inheritance, okay? What's the second part of that? And he can't pay the life insurance premium. You don't get to choose. You have to do both. And the second portion of this agreement, which the appellant says is unconscionably written against him, would allow him to merely say, can't pay this month. And I don't think that's fair, and I don't think that's what the agreement means. Now, of course, if the inheritance issue was decided in favor of respondent's position here, one need not reach the second point. But the second point, it's unconscionable. It's unconscionable the other way around. That this man can just turn around after this marriage, and in order to protect this inheritance, which he claims he hasn't received, but he has all this money.
Well, they were married for a considerable period, I think 28 years.
Yeah.
28 years.
Yeah, really. So what I'm saying is after this long-term relationship, to turn around and be able to cut off the wife based on merely his, I suppose, good faith, doesn't even say it has to be in good faith, agreement that he can't pay seems unconscionable to me.
Thank you.
Thank you, Your Honor.
Just very briefly, Your Honors.
So, counsel,
Yes.
I thought that the record bore certain canceled checks and evidence that there were distributions after the father died, but prior to the mother's death, from the trust to your client.
I was actually going to bring up the trust in response to that point. So I have all the trust documents here. They're all in the record. Every single one of those trust documents is his mother's trust. His father did not have a trust. I don't know what happened to his father's assets. I do not know what happened. I do not know if his father had any assets. But every trust document here is his mother's trust. So there's really, and this was not an argument that was made by the respondent in the lower court that he had received an inheritance from his father, because there's simply nothing in the record supporting the idea that he had received an inheritance from his father. On the issue of unconscionability, very briefly, To say cut off the wife is fairly ridiculous. He is paying 10% of his income for the rest of his life to her as and for maintenance. There has been no allegation that he ever ceased those payments. What we're talking about here is sharing an inheritance, which is statutorily under the domestic relations law, separate property. An inheritance.
That doesn't preclude the parties from making an agreement as to how to divide it, which is what they did here.
I agree, but I think with this agreement and these provisions, it reaches the level of unconscionability. The combination
Your
of
client had a lawyer when they did their first post-nup, and then he chose not to have a lawyer when they did their second post-nup. So why shouldn't he be bound by an agreement which he chose to sign without counsel?
because the agreement reaches the level of unconscionability due to all of the provisions. Now, one factor in an unconscionability analysis is whether he was represented by counsel. I agree with you. But the record did show, from the first agreement to the amended postnuptial agreement, a radical change in the agreement. The first one, he had counsel. The second one, he didn't. In that interim time period, an $83,000 obligation was placed on him that
You don't discuss in your papers there's no allegations of force or requirements that he do whatever she said. There's nothing like that. I don't understand how you get to unconscionability.
He did allege that his wife at the time threatened to evict him from their shared apartment, which was only in her name, if he did not sign the agreement. There was also an affidavit from his...
So she was threatening to do something that she had the right to do so?
Whether she had the right to evict her own husband, I'm not sure about that. But she did threaten him. I did not see that in the papers, though. That is in the papers.
So I'll take another look at it. Thank you very much.
Thank you, Your Honors.
Harlick v. Laura. Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court, Jack Lockwood for the Plaintiff Appellant. The Supreme Court here erred in granting defendant's motion for summary judgment dismissing the complaint. With respect to prior written notice, to the extent that the statute applied at all, there was an exception here in that the work immediately resulted in the existence of a dangerous condition. The city also had actual notice of this, as they claim in their papers, that they actually inspected this temporary pedestrian signal after it was installed. It's part of their argument that it was correctly installed. We also argue that the prior written notice laws do not apply to they apply only to physical conditions of the roadway or sidewalk.
Counsel, what standard did the city rely upon to say that the temporary lights were installed properly?
The city did not identify a standard, Your Honor. They said that the standards that are applicable to traffic signals only pertain to permanent traffic signals, and that there is no minimum or maximum height requirement for temporary pedestrian signals. That's unsupported by any of the regulations.
Counsel, since there's no standard and we have two experts with diverging viewpoints, doesn't that present an issue of fact?
Absolutely, Your Honor. This is a classic battle of the experts, and the Supreme Court erred in crediting the defendant's expert over plaintiff's expert, and it incorrectly granted summary judgment on that issue. With respect to causation, defendants argue that as a factual matter, that plaintiff did not look to see if there was a pedestrian signal when he was crossing the street. This is contradicted by the plaintiff's testimony, where he was specifically asked, when they're talking about pedestrian, don't walk, walk signals, do you remember looking for one? Quote, yes, and you just didn't see one. I didn't see one. That's at 20,
Didn't
30.
the city also argue that they had done it this way before and therefore it was good enough?
I think that they do make an argument that this is standard practice and procedure. I don't know that. I think that they were more referring to the fact that this was placed on like a pylon or something, and more addressing the fact that a temporary signal was needed. I don't believe that there's evidence demonstrating the height of other temporary pedestrian signals in the record here. So to the extent that a witness may have said that, we would argue that that's conclusory. In any
Even
event,
if they had done it before, that wouldn't establish that it was non-negligent.
absolutely, Your Honor. They could have just been negligent previously, and luckily no one got hurt during that incident. With respect to the contractors here, we believe that there is an exception to the Espinal line of cases that the contractors launched a force or instrument of harm when they improperly installed this defective and dangerous pedestrian signal. They created and caused it, and it was immediately dangerous at the moment that they installed it. Therefore, they owed a duty to plaintiff. And in addition, we note that under the contractor's agreement with the city, they explicitly states, quote, "The contractor is responsible for the safety of both pedestrians and vehicular traffic for the duration of the contract." That's at page 1776 in the record. I'll wait for my colleague's argument, and then I'll come for rebuttal. Thank you.
Thank you.
May it please the court, Nicholas Calabri with Omni Demirs and McManus for the respondents in this matter. I believe the court correctly granted summary judgment to the defendants in this matter, while the appellant says that there is a battle of the experts, and that should raise a question of fact. I believe
What standard of, did the city rely on in arguing that this was a safe or appropriate method of installing a pedestrian light?
Sure, they relied upon a New York City Department of Transportation standard sheet F1000, which the city engineer in charge, both contractors, engineers, and the expert testified was complied with.
And did that specifically govern temporary installations like this?
Correct. That's on page 2409. It had to do with the pylon that would be placed temporarily while the construction work was ongoing, and then the old.
I thought that the testimony was that there were no specific guidelines as to temporary.
Regarding height, there are none.
Oh, okay.
Okay.
Well, that's what we're basically concerned with, right?
Right, and the plaintiff's expert, in his affidavit, stated that a permanent one has to be between 7 and 10 feet at the bottom, and he said that there was a section of the manual on uniform traffic control devices concerning temporary, and he said that because of this provision, the permanent height, the 7 to 10, is necessary in the temporary, but that is not what the manual says.
Well, if we could just back up to your presentation, because your motion for summary judgment, so you have to make a prima facie showing in the first instance before the burden shifts. How did you discharge that prima facie showing here with respect to the negligence, due care?
Sure, but regarding the height of this, which is the allegation, our expert presented a study regarding sight vision of
Right. So
someone at his height.
how can an engineer, an expert, opine as to what an individual can or cannot see? So your expert stated that the signal would have been within plaintiff's field of view. How would he or she be able to opine as to that?
It was based upon a study, I believe.
A study,
Yes.
but did the study involve the plaintiff or an individual?
No, a reasonable person, height, distance that they can see.
A study, right? So
It's a scientific examination regarding what you can see from different
What
distances.
makes it a scientific study? And how are we defining a reasonable person's height?
Well,
So
again,
the question is, how can you tell what I don't know whether you can have a reasonable person who's 6 feet or an unreasonable person of 6 feet, but let's put that aside. How do you opine as to what a person whose height is 6 feet can or cannot see?
well, there was, again, he cited this study that was a scientific study that said a person looking straight ahead can see.
So you can tell
so
me,
high, so-
my person, me, you can
Yes.
tell me
Well,
what I
I
can
wouldn't do it.
see?
I would
No, I'm
let my
sorry, your
I would
expert
let my expert
would be
do that.
able to tell me what I can see in terms of the officers at the back of the courtroom.
no, what's-
Scientifically,
What's to be seen?
what's to be seen?
I mean, if he was there
Excellent,
like this-
excellent.
Right.
What's to be seen?
Correct.
Now, we have the plaintiff who says he did not see it.
Right, and he didn't see there was.
So
there
your
was
expert says, you know what? Based upon this scientific evidence, he should have seen it. And even though he says he did not see it, he's incorrect?
No, that the height of this sign was reasonably placed so that a reasonable person could see it. Yes, that's what the study said.
But counsel.
And again,
your
I just
expert
wanna-
Your expert was a professional engineer.
Correct.
So there's some study published by somebody.
Right, and he
who
cited
claimed-
it.
Excuse me, which is within his also by another professional engineer. Who is that from? Why should we rely on that study?
Because it's a scientific study that's reasonably accepted in the community.
What community?
The accident reconstruction community.
Oh, thank you.
What was the basis, what's the basis for that it's generally accepted in that particular community?
The expert said it?
No, that it was published, peer-reviewed, and therefore cited in his report.
So are you saying that any expert can testify about a published study that claims to be scientific?
Well, no, I'm not trying to say that at all. All I'm saying is, if you're 5 foot, I think he was 5'7", his eyes were at 5 foot, he'd be able to see in his range of vision up to 18 feet. It's reasonable that a person, you would have to make that sign under 18 feet. This sign was. Now,
If the person does not see it, even though this scientific study says that they should have seen it, does that not create a question of fact for the jury?
Why not? He says he didn't see it.
okay, so say that's like just running a
So
red
we say,
light.
oh, you know what? Yes, you're right, because this scientific study stated that you, as a reasonable person, should have seen it. So therefore, that's it?
If someone ran a red light,
Yes.
and he said, I didn't see the red light.
Yes.
But the car behind him said, yeah, I saw him run a red
So
light.
under your theory, if there's a scientific theory that says I should have seen that red light, and I said I didn't see that red light, then your scientific theory, your study trumps my statement as to what I did or did not see?
No, but it's just not, I mean, the person that ran the red light can't say I didn't see the red light if everyone else says the light was red.
Really?
Yeah.
There's no issue of fact there.
No issue of fact there.
Okay, thank you. Makes it easy.
Your Honors, the
There's
plaintiff.
no issue of fact.
There is an issue
You
of
said
fact.
there's no issue of fact. So what are you? Why are
This
you
is a
here?
summary judgment motion, Your Honor. As everyone's aware, plaintiff is entitled to every credibility determination and every favorable inference here. There is a triable issue of fact as to what he saw, to the extent that the expert is opining that he should or could have been able to see it. He testified that he didn't see it.
Did your expert review this scientific study of the other expert as well?
I don't believe that he specifically addressed that study that the defendant's expert was relying on. However, we argued that in opposition that the defendant's expert failed to lay a proper foundation for his opinion. This is really not all that different from allegations that something is open and obvious. I mean, if they create
What was the deficiency
a deficiency in
in the
the
defendant's proof?
defense.
They didn't lay a proper foundation, so where's the hole there?
Oh, the whole is that it didn't take into account, first of all, it didn't measure the actual pedestrian signal. They never inspected the site. He cites to some general studies that were done, but doesn't take into account the actual characteristics of the
So
defendant.
is it there's not a factual basis tied to the facts of this case supporting the defendant's expert's position?
Correct, Your Honor. Therefore, it's speculative. The opinion, it doesn't take into account material facts. Again, even if it is credited to establish this fact as to what he could have seen, that would merely go to an issue of comparative negligence. It does not establish sole proximate cause. Same with open and obvious. You can't dismiss a case based on open and obvious nature of the dangerous defective condition.
Well, there was testimony that there are other individuals, I think, who also crossed and there were no issues.
That's an inference that's drawn from defendant's interpretation of the testimony. On this motion, plaintiff is entitled to the benefit of every favorable inference.
Counsel, your friend held up a piece of paper and said that that set forth the standard to be used for temporary installations
yes, Your
of this
Honor.
type, and cited a page in the record which didn't have a piece of paper like that on it. Do you know what he's referring to? Or did that
Yes, Your
set a
Honor.
standard?
He was citing to page 2490 in the record. I quickly reviewed it while he was arguing. It's a standards sheet. There are no height standards on there talking about how tall it's supposed to be. Plaintiff's expert cited to city standard and federal standards that say it's supposed to be between 7 and 10 feet. It's uncontested that this was 12 feet 7 inches above the floor or above the ground level, and the MUTCD specifically says that temporary traffic control devices should be should meet the same standards as permanent ones to the extent it's possible, and it was certainly possible here. It was connected by a metal band that could have been moved up or down very simply.
Thank you.
Thank you, Your Honors.
LNV Corporation v. Cordero. Yes.
May it please the court, Gerald Roth, Steinwiener Roth for respondent. I recognize that the appellant is not here, but I hope the court will indulge me for several minutes to go through the underlying foreclosure action. The underlying action is an action to foreclosure mortgage in Bronx County that's been pending since 2010 with a default date 18 years ago. During the course of the action, the appellant borrower served an answer with defenses, but summary judgment was granted. That answer was dismissed. The parties even entered into a stipulation confirming the dismissal of that answer, and a consent judgment was entered into. A judgment of foreclosure and sale was entered on consent in 2019, yet it is now 6.5 years later, and the respondent is still unable to enforce
So,
that
counsel,
judgment.
we are aware of the chronology. Is there anything else you wanted to add in terms of why the Supreme Court's decision should be affirmed?
Well, essentially, the entire motion is based upon an attempt to regurgitate these defenses that have been dismissed, considered, knocked out several times over.
And were in fact waived by the homeowner, correct?
I'm sorry?
And were in fact waived by the homeowner some years ago.
Correct. Voluntarily. We have a prior motion which sought to vacate the judgment of foreclosure and sale and the stipulation, which was denied by the lower court and is not subject to this appeal. This is the second such motion seeking the same relief. We understand that there are, procedures in place to protect homeowners from losing their homes, but, it's the respondent's position that this is a gross abuse of the process in the foreclosure action, and we just are looking for the court to acknowledge this and to reject this appeal. There's absolutely no basis to the appeal whatsoever. It's all based upon defenses that have been adjudicated, dismissed, waived, however you want to call them. A prior motion for the same relief was denied on the merits and not appealed, and therefore, this motion is a regurgitation of the prior motion. There's absolutely no legal or procedural basis for the court to consider it or grant it.
Thank you.
Thank you.
Yang v. Knights Genesis Group. Yes, you may proceed.
Thank you, Your Honors. May it please the court, Derek Soler from Bailey Duquette, PC. I represent plaintiff appellant Frank Yang in his appeal of an order of the Supreme Court ordering that 60% of the amount he received when enforcing and executing on a judgment be given to another plaintiff, a plaintiff intervener, who is the respondent in this appeal. This matter started with a fairly standard sequence of events in New York courts that went in a very unexpected and
So,
unprecedented
counsel,
direction.
you are appealing the July 16, 2024 decision, is that correct?
That's correct.
Okay, and in that decision, the court granted, pursuant to CPLR 2606 and 2607, the release of the 60% pro rata share. Is that correct?
That's correct.
And why was that incorrect?
Well, because that amount had been in the possession of defendant, when defendant had a judgment issued against them in favor of plaintiff. Plaintiff executed upon that judgment.
How do you square that position with the court's other orders from, I think it was January 5th and January 6th? Which specifically stated that the court was to retain the subject funds based on the court's understanding that there were other individuals that might be entitled to a portion of those funds.
Well, that's easy. That at that point, there had already been an execution served by the sheriff.
The court
money collected.
Didn't the court vacate that execution specifically?
Well, I be curious to see where they did that. The word vacate is not included in any of the orders issued by the court. They don't discuss under what authority they might have vacated the execution, and we have not seen any examples of that happening.
But didn't the court clarify that the funds were to remain in escrow until the whole matter was adjudicated?
They did, and that's interesting to me too, because how would they have been held in escrow? Under what authority, right? What happened here was that plaintiff brought an order of attachment and an order for preliminary injunction.
Did you appeal those orders, the January 5th and 6th orders, where the court directed that those funds be held in escrow?
No, and because the court, it was a preliminary injunction. By its nature, the court was going to revisit that motion. It was a non-final order. To the degree that it needs to be disturbed, it can be here under CPLR 5501, as this is the final relief in this dispute between the parties.
Well, we could only review a prior order if it materially affects a judgment, and we don't have an appeal from a judgment before us. We have an appeal from an order.
That's true. Well, but it's an order that it's a final disposition of a matter in dispute. And in the past, the Court of Appeals has made clear that such an order should be treated as we have sometimes orders that are in fact judgments in their nature as they finally decide a matter in dispute between two parties. There were no claims between the parties here. So there could be no judgment as between the rights between these parties here. The question was, the sheriff went and got funds that were held that was not contested, were the property of the judgment debtor in this case. It was a valid judgment. At this time, the other plaintiff intervener, was not even a judgment debtor.
So, sir, in your view, what did the court's January 5th and 6th orders do?
Well, the January 5th and 6th orders ordered the plaintiff to allow the money that it had executed upon to be placed into escrow while the court decided what the proper distribution of that money was going to be. And I'm sure counsel believed, in compliance with Article 52 of the CPLR and rules on priority, and the fact that when it executed its judgment, there was not even another judgment creditor around, and the fact that it's not up to the courts to protect other potential judgment creditors, or even current judgment creditors, unless it's a bankruptcy court that's faced, of course, with a party that is known to be impecunious, and there's not enough assets to go around. That was not the case here.
But at that time, the intervener plaintiffs had already intervened in this proceeding, and they were properly before the judge, weren't they?
That's true, they were. But that doesn't affect whether or not they had any rights to any of the assets of the defendant. The only reason that any of the assets of the defendant could have been before the court is because appellant, filed for and won and was received a motion for an order of attachment that protects it, not all creditors, just it, and a preliminary injunction that only enjoined the defendants from alienating money while plaintiffs' action was ongoing. And that's what those orders are for. When you get an order of attachment, it doesn't attach the money for anybody. It attaches it for you if you win your case.
Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Glenn Lenahan with Oved and Oved LLP on behalf of respondents. The entire appeal by appellant here is premised on the false notion that he had a valid execution. As this panel has asked questions of my colleague, by the January 5th and 6th, 2023 orders, the court made very clear that the appellant did not have a valid execution.
But back when, in October 21st of 2021, the court issued an order which is actually not in the record before us, but which the court conveniently described in the order that is on appeal. And his description of it said that he had issued execution for the plaintiff.
So the court clarified in several orders thereafter that it did not give immediate execution.
But that was 2 years later, right?
Well, no, it was also in the January 6th, 2023 order.
Right. So we're talking about 2021. In 2021, it indicated that Mr. Yang could have execution thereon, right?
It could at some time have execution.
And that's when the clerk issued a judgment against the defendants.
Well, only against one of the defendant, that's 1989 investor.
Right.
And at that point, we had intervened, and as the court noted in its orders, we did not oppose that default judgment because of the existence of the injunction and the attachment that said this money is going to be held pending adjudication of this matter. And as the court made—
Had you intervened prior to that order that the court indicated that the plaintiff could execute the judgment?
Yes, we had. Yes, we had. But by that time, at no point did the appellant ever go to the court and seek to dissolve or modify the injunction that required that the money be held in escrow. And the court made very, very clear through two orders that the appellant did not have a valid execution.
Well,
and
your
appellant never appealed
adversary
that.
essentially is saying that based on that previous order that they did have an execution of judgment and that the court had no authority really to say that they didn't have an execution of judgment, even in the orders that clarified the court's position. How do you respond to that there was no authority for those orders?
Well, I disagree with that entirely. The court did not say you shall have immediate execution in the October 2021 order. And if you read that in conjunction with the April 2021 order, it's very clear that these funds were required to be kept in escrow pending final adjudication of this matter.
Well, the April 2021 order stated that the funds would be held in escrow.
Yes, yeah, pending adjudication.
Pending adjudication.
And as the court made clear, based on the appellant's own averments to the court at the time, there were other investors who in fact had invested more than the appellant in this.
Where did the court make that clear? On the record or in any decision?
Oh, in the January 5th, 2023 decision, when it said it was clear to this court when it issued the preliminary injunction that Mr. Yang, the appellant, was not the only investor in this alleged fraud and that such money needed to be set aside as potential other plaintiffs came out of the woodwork. Thus, no execution.
Is there anything indicating that between the issuance of the October 18th order and the order you just referred to?
I apologize. Can you repeat your question?
Was that ever made clear between the date of the October 18th, 2021 order and the January 6th, 5th and 6th, 2023 orders?
Well, I suppose when the court signed the TRO preventing the appellant from continuing to execute upon this.
So that statement that the court makes in the order that says it was clear to the court, it may have been clear to the court, but was it clear to the parties? That was clear to the court.
More importantly, would it have been clear to the sheriff? The sheriff was going to be presented with the document that said plaintiff shall have execution thereon. The sheriff looks at that. There's nothing conditional about that.
No,
It seems to me that at that point there was a valid execution, and the real issue is, did something happen on January 5th and or 6th that invalidated vitiated that otherwise valid execution.
Yes, the court's orders of January 5th and 6th made very clear that thus no execution based on the Yang default judgment was appropriate, and then went on to say in the January 6th order, no execution was intended to be permitted prior to the full adjudication of this case on the bankruptcy distribution, meaning
How
that
is
the
the
funds at
plaintiff
issue.
supposed to have known that when the October 2021 order said granted him a judgment with execution thereon?
Because it didn't grant him an immediate execution. The court then made clear it was vacating the execution, and the appellant never appealed that vacation or vacator of the execution. So he cannot appeal this now.
What specifically did Supreme Court do in its orders on the 5th and 6th? What did the decretals say? Not any rationale or background explanation, but what were the decretals in the January 5th and 6th orders?
So the January 5th order, with respect to appellant, simply said, it is hereby ordered that plaintiff intervener's motion for preliminary injunction and temporary restraining order, motion sequence 10, is granted. The January 6th order did not have a decretal. It simply said that the intention was that this would occur, meaning the execution would occur only after full adjudication of this case, given the requirement that the bankruptcy distribution be held in escrow. No execution was intended to be permitted prior to the full adjudication of this case on the bankruptcy distribution, which our clients relied upon. So when the court vacated this order and it was not appealed, and the appellant at no point moved to modify, to clarify, to dissolve the injunction, that was the law of the case. He should have appealed at the time if he disagreed with it. He should have appealed at any point prior to that. Instead, he waited for this decision in which the court made very, very clear that it previously vacated the execution by Mr. Yang such that he cannot rely on CPLR Article 52. And even if he could, even if he had an execution, it would still be improper based on this court's decision in the matter of Anderson-Kill, which is incredibly similar to this. It was a 2015 decision where this court affirmed the lower court. There, judgment creditors entered into an agreement that certain assets of a debtor were going to be held in escrow, pending either the joint agreement of the two creditors or an order of the court. One of those creditors, with neither of those things happening, based on a confession of judgment, went and executed and obtained the full 100% of those escrowed funds. The lower court said, no, you may not do that. It doesn't comply with the agreement that you'd entered into, regardless if you got a judgment or not. It went up to this court, and the court said this court said very clearly that the lower court was correct. Excuse me, I'm sorry. Was barred from executing the escrow funds because the terms of the escrow agreement were not met. That's what happened here. There was an order from the court saying this is going to be held in escrow pending the final adjudication. Nothing ever changed with that.
Is it a material distinction that in Anderson-Kill there was an escrow agreement between the parties, and here there were orders that seemed to be a little bit dynamic in their content over a period of time?
I view it as a distinction without a difference, to be perfectly honest, Your Honor. They were both binding writings that set forth what people could and could not do. Here, this order said this is to be held in escrow pending the adjudication of this matter. After we intervened, they could have moved to modify that, to say, no, it's just for me, just for my claims. Of course, we would have opposed. We would have said it should be for everybody. The court should extend the injunction, but they didn't do any of that. They didn't move on notice, giving us the chance to oppose. They surreptitiously went, issued this execution. Once we found out, we promptly went to the court, obtained the vacatur of the execution. The court directed the sheriff to deposit the funds with the court, which is another reason that even if he had an execution, it wouldn't matter. You can't execute on funds paid into the court. You can only get those pursuant to CPLR 2606 and 2607 when you have an order. Thank you.
Thank you.
Thank you, Your Honors. Just a couple points of order. There was a mention of a quote from the order saying, I vacated that previous execution. Again, I don't believe the word vacate or I vacated the execution is in that order appealed from or any other order of the court in this case. And if I'm wrong, please let me know and let the court know where that is. But I don't believe that was said. Secondly, again, not one example of an execution being vacated in any case has been introduced by the court here.
What was the
by my
plaintiff's
friend.
understanding of those two orders, how those orders related to the case at all?
January 5 and January 6.
Well, it was that the court had made a temporary mistake and wanted to get its ducks in a row and understand what was going on here before it decided.
And the temporary mistake was issuing an order that had an execution of judgment or
No, of
something
course,
else?
the temporary mistake was ordering us to put it into escrow. It didn't order us to give the money to the other side yet. It just ordered us to put the money into escrow.
January 5 and January 6, the court enjoined you from executing the default and directed the funds to remain in the court's possession.
Well, they were not in the court's possession before that point. They were in the possession of the bankruptcy debt of the bankruptcy trustee until the sheriff, with the order of execution. Now, and this is
So
one
your
thing-
understanding of the court's mistake was what then? You said that your understanding of those orders is that the court was rectifying a mistake. What was the mistake
I'm
being
sorry.
rectified?
Our understanding was the court had made a mistake. That's plaintiff's understanding.
Okay, so if your understanding of the January 5th and the January 6th orders was that they were in error, why then, again, did you not appeal?
Well, because the court was reserving, it was preliminary in nature. The court had another chance to make it right. It hadn't decided what it was going to do. And since the law is so clear under Article 52 of the CPLR and under, and under Articles 62 and 63, again, orders of attachment, the court doesn't, in no case have we found one plaintiff going to get an order of attachment at its benefit, and that money going to any other plaintiff, judgment creditor, any other party.
So, as my colleague stated, since the orders in 2021 were somewhat dynamic, and, you had issues with the January 5th and the January 6th orders, thinking that, again, perhaps the court had made an error, I'm still not understanding, given perhaps what had occurred in the past, you would not immediately have appealed or at least moved to re-argue the decisions of the court.
Well, I personally can't speak to that, as I was not counsel at that time. I understand that there were financial implications in launching an appeal. It should have been a lot quicker for the court to come back, to be honest, the Supreme Court to come back and come
No,
with
but
a
the
final
point is,
disposition.
why then, as your friend stated, why then wait until, the last minute to now come in and say this was incorrect?
Well, we just waited until the court had a final disposition, that's all. There was no reason to have the added expense of an appeal, and that could be on appeal while the court came in and said, oh, you're right, I got it wrong. You executed that money. I have no authority to protect the world, to take the money that you got through an order of attachment or that was retained based on an order of attachment and protect the world.
Thank you. Thank you both. Morales v. New York City Housing Authority.
May it please the court, Andrew Kaufman from Miranda Sloan, Squire and Verveniotis for the appellants. Your Honors, the trial court here properly determined that the defendant appellants met their prima facie burden when they moved for summary judgment. It was this affidavit from the plaintiff that seemed to give the court some reason to deny the motion. At the outset, I'd like to say that the plaintiff and NYCHA never disputed the propriety of the Corso affidavit that was submitted in the underlying motion papers. In fact, NYCHA admitted in its answer that it owned, maintained, and managed the premises on the date of the accident.
But
That's
that
at
doesn't
page
establish
55.
that Mr. Corso had personal knowledge of what he swore to in his affidavit.
Well, Mr. Corso is part of the real estate
Well,
conglomerate.
being part of a real estate conglomerate doesn't mean that the person knows everything about that goes on in the real estate conglomerate unless they're involved in it on a daily basis.
Well,
Or have some other basis for knowing about it, right?
the affidavit was actually supported by documents that were submitted with the record as to when the property was ultimately sold. And Mr. Corso did aver that there was no work being done until January of 2023, which was months after the plaintiff's accident.
And to go back to Justice Gessmer's point, what was the basis of Mr. Corso's, of that statement of Mr. Corso's, that the work hadn't started till that point?
Because they didn't have the right to do any work.
Well, wasn't there a meeting, a notice to all the tenants that there was a meet and greet, and then work?
Well, actually,
It was
you referred to it as a meet and greet. That's not what the
Correct.
flyer stated. It says, please join us for our first resident meeting to introduce ourselves to you. We will provide an overview of the PACT program, our timeline for the renovation of your building, and the transaction to new property management. So it wasn't a meet and greet. It was, again, it was supposed to be, according to the flyer, it was an informative meeting to introduce and also to state the timeline for the renovations.
right. And
That was on November 1, and the work started a week after that. So,
some work started, but not by
Fine.
my clients, because the management agreement didn't take place till the following year, which is confirmed through all the documents that were submitted in the record and which were on NYCHA, which the parties had notice of. Sorry, not on NYCHA, they were on NYSIF, which all the parties had notice of.
So I'm looking at Mr. Corso's affidavit, paragraph 6. NYCHA permitted us to perform pre-conversion work on the property, but not until January 12. No work was performed by any of the entities described above prior to January 12. Where does Mr. Corso state the basis for that statement?
There's, in the record, Your Honor, there's on pages 188 and 189,
Does he refer to those in his affidavit?
not specifically.
Okay, but the question
Not even specifically. I just read to you what he said.
Yeah.
This is paragraph 6. This is what he stated.
So on 185 of the record, there's the schedule of when any work can take place, and it's consistent with his, the dates are consistent with his affidavit. You know, the plaintiff said,
You still haven't told us what in his affidavit shows that he had any personal knowledge of any of this. And I just don't see it.
his entity is the one that formed the organizations that ultimately took over the management of this building.
Yes, we know that. He states that in the affidavit. But again, he does not state in the affidavit the basis for his statement that no work was performed by any of the entities described above prior to January 12, 2023. He does state in paragraph 7, I reviewed the summons and complaint in this matter. So he did apparently have the ability to review documents. He does not state that he reviewed the work schedule or anything of that nature to lead to the conclusion that no work was performed.
Well, I think as his affidavit clearly discusses the project development in paragraph 4, and in paragraph 5, that the entities that were sued had no proprietary interest in the property and performed any labor at the property.
Paragraph 4, all he talks about is progressive formed union housing preservation to function as a project developer. That's what he talks about in paragraph 4. Paragraph 5, he talks about Omni was partners with union housing preservation, that the partners never had any proprietary interest. And then again, paragraph 6, he talks about no work was performed by any of the entities. Again, he does not state the basis for that statement or how he would even know that none of the entities performed any of the work. But you do have time on rebuttal.
Well, I would say that night.
You can say that on rebuttal. Thank you.
Good afternoon, Your Honors. Edwin Rahimi from Harris, Keenan, and Goldfarb for the plaintiff respondent. Most importantly here, plaintiff's affidavit raises the critical factual issue of whether the defendant, the appellants here, through their agents or contractors, had begun preparatory or renovation-related activity in the building resulted in the debris being present in the hallway before the formal construction date they rely on of January 12th.
If you're moving to plaintiff's affidavit, are you conceding that defendants established a prima facie basis for a summary judgment in their favor?
No, I'm not conceding that. It's that even though if yes, in Mr. Corso's affidavit, if he's claiming he has no proprietary interest, that is not, still doesn't address the special use or control of the premises which the lower court held. Even assuming the affidavit satisfied a prima facie burden does not eliminate the factual issue raised by plaintiff's affidavit. It does not address whether workers were present in the building earlier, whether site walkthroughs, inspections, or any preparatory work occurred, or whether materials were already being handled or moved through the common hallway during this transition period. And that's why the motion, the summary judgment motion that was brought was premature. At the time it was sought, there were no depositions held. Plaintiff had no opportunity to question project supervisors, site managers, coordinators, or other supervisory personnel who would have direct knowledge of when the workers first entered the building or what activities they performed and whether materials or debris were moved throughout the hallway where the plaintiff fell. Plaintiff, as a tenant, she can only testify as to what she observed. She cannot testify as to the timing of the on-site activity, and that information lies exclusively within the defendants. Plaintiff specifically identified the location, the condition, and the specific time frame. And most notably, the appellant's names were posted on that letter from the meeting that was supposed to be held on November 1st, which is only 12 days prior to her fall. And the discovery that still remains would help, show this special use as to the testimony from supervisory or on-site personnel about, again, whether the workers were present, whether activities resulted in debris in the hallway before plaintiff's fall. As this is a case about the plaintiff falling on debris, it is perfectly valid that within the 2-month period, if Mr. Corso's affidavit states that January 12, 2023, work was to begin, that does not address whether materials or any preparation was done in that 2-month period from the November 1st meeting up until the plaintiff's fall on November 12th. It could perfectly well be the case that workers were already going in and out of the building, placing materials throughout, leaving debris out in the hallway. So because the plaintiff's affidavit raises a factual issue as to control or special use.
But we don't have to get to that because your position is that the defendants in moving for summary judgment did not make out a prima facie case. Is that correct?
Correct.
Thank you.
Hi, Gretchen Beck for Newman Myers Cranes Harris for defendant respondent New York City Housing.
I'm sorry, you represent whom?
Defendant respondent New York City Housing Authority. Just agreeing with what was stated, we joined in, just to correct also what Appellant said, NYCHA joined in with plaintiff's opposition, and plaintiff did dispute the sufficiency of Mr. Corso's affidavit, saying that it was conclusory, which it was. He, like you said,
go beyond that?
no, you don't. Obviously, if he doesn't meet his prima facie burden, you don't need to consider the opposition, the sufficiency of the opposition, and he clearly didn't meet it. He's a non-party. He has no basis of knowledge of anything. They only formed a non-party. They didn't form the appellants. He specifically says they only formed the non-party and that the appellants were apparently purportedly partners. There's no evidence of this. And if you look at the flyer, it says otherwise. It says they're partners of a different entity, actually, not the non-party that he apparently formed, Mr. Corso. So it really, the affidavit, I think, is really just sort of, it's not sufficient at all to meet their burden. So I would deny the motion just based on that and affirm the court's order on that ground, on different grounds. Thanks.
NYCHA was in the best position to dispute our arguments. NYCHA submitted nothing, no documents.
But if you don't establish a prima facie case, there's nothing for them to dispute. And you still haven't shown us any basis in Mr. Corso's affidavit for your claim that he had personal knowledge of the conclusory statements in his affidavit. I still don't see any basis for that.
Well, I disagree with you, and obviously the trial court disagreed with you that we did meet our prima facie burden. Thank you.
Thank you. Alonzo v. RP 1185 LLC.
It please the court, Your Honors. My name is Scott Singer. I represent the plaintiff appellant in this case. Supreme Court, in concluding the plaintiff hadn't made out a prima facie case, said that the plaintiff injured his shoulder as he attempted to grab the piece of thick rebar he had just dropped. His injuries were not the result of a fall he suffered or being struck by a falling object.
Well, he didn't fall.
That's correct.
And the reason he didn't fall was because of the harness. The harness prevented him from falling,
No,
right?
that's not, the harness doesn't always prevent you from falling. It prevents
Well.
you from falling a very great distance. And in this case, it did not prevent him from injuring himself.
But he didn't fall.
He did fall. He went down approximately, he described it several, I think several inches, and then he grabbed the rebar.
So he was kind of hanging off the wall, right?
He was hanging off the wall. He put his feet on this, he wasn't given a platform. He put his feet on a thin piece of rebar that was obviously unstable because he wasn't given a platform to work on. And he was holding on to the rebar in front of him with his foot on the thin rebar below him, and the load was passed to him. I mean, he wasn't given a hoisting device. There was nothing to support it. This was a terrible system. There were cranes that had been used on the site before. They could have been used again. He was not given a crane, even though he absolutely should have been given one, and there are many cases holding.
So Supreme Court said that you failed to establish a prima facie case because the injuries, you failed to show that his injuries were the result of a fall he suffered or having been struck by a falling object.
Well,
They said, Supreme Court said rather, his injuries were caused by ordinary perils present at a construction site.
Well, then they would have to say that Mr. Runner, when he got his thumb pretty much destroyed, that was also an ordinary injury at a construction site. It wasn't. It was caused by gravity. The plaintiff's injury here was caused by gravity. This is well within the purview of Section 240, and I cite the cases Colback and Scow, all cases where somebody is attempting to prevent an object from falling, and it's considered a gravity-related injury. Since the defendants didn't provide a stable platform. By the way, their foreman conceded, no, he didn't have a stable platform. He didn't have a stable platform to work on. He didn't have a hoist to support, which would have supported the load and would have avoided the accident completely. He didn't have a hoist or a crane or a similar object. There was a total failure to provide devices required by Labor Law Section 240. So if there are no other questions, I'll rest on my brief.
Thank you.
Unless something else comes up and I need to rebut. Thank you.
Good afternoon, Your Honors. May it please the court. Zachary Taylor representing the defendants, respondents, RP 1185 LLC and Lend-Lease Construction. As you've already pointed out to the plaintiff appellant, he did not fall. There was a harness attached to a lanyard above him with two lanyards in front of him to allow him for power and leverage to accomplish the task. Plaintiff testified that the rebar...
So the hoist was the sufficient safety device here?
There was no hoist with regards to the rebar.
Well, the harness.
The harness was the sufficient safety device to prevent the plaintiff from falling, yes.
Didn't prevent him from slipping off the rebar he was standing on when he was trying to catch the heavy rebar being handed to him, right?
With respect to standing on the rebar, that was a decision that was made by the plaintiff to stand on that, and it's something that's done.
Well, weren't there two other co-workers and they were standing on rebars as well, but their rebars were much larger, not the size of a penny as the one that plaintiff was standing on?
And how can we call it a choice if he wasn't provided with anything else?
Right, regardless of whether the rebar was that his colleagues were standing on was larger or not. I mean, again, were you not tasked with having a proper platform, a foundation for him to stand upon if he's going to be holding on to and moving heavy rebar?
With respect to his coworkers immediately to his left that were also hanging, they had their feet on a form that was left from carpenters. They did not have a platform that was provided by Duchess Rebar, or they did not have...
They were standing on a wooden platform. They weren't balancing on a thin piece of rebar, correct?
Correct, but that was left over from carpenter work.
Would you dispute that standing on a thin piece of rebar is less stable than standing on a wooden platform?
I would not dispute that. However, what I would say is that plaintiff is there hanging. He's testified that he is grabbing the wall, that he's inserting the rebar with one arm and guiding the other rebar into the wall. As opposed to using a platform to prevent the plaintiff from falling, that's what we use the harness and the lanyards for.
But it didn't succeed.
They succeeded because plaintiff didn't fall.
But he was still injured.
He was still
How about
injured because of.
the falling object aspect of the case, the rebar that was being handed down from the coworker?
So with regards to the falling object, we do not believe that the rebar constituted a falling object, as the rebar was 25 to 30 feet in length. Plaintiff was only holding a part of it. His other two coworkers to his left were.
Does that square with the case law in this department, that analysis?
With respect to the case law, all of the cases cited to by the plaintiff deal with objects or something that was fallen that had a substantial weight or a unsupervised or inadequate descent. A lot of the cases reference bundles of rebar, concrete slabs, things that weigh in excess of 300 pounds. Some of the cases cited include objects that weighed 8,000 to 10,000 pounds.
I guess it's contextual, right? If you're standing on 2 feet on solid ground, maybe you're able to tolerate or deal with a greater weight, whereas if you're balancing yourself on a rebar 10 feet above the ground, you're only able to manage one ream of rebar at a time.
The rebar was being, so there, you have the plaintiff, and then 5 feet to his left, you have a coworker also hanging. 5 feet to their left, another coworker, and then you have somebody on a deck passing the rebar from, if I'm standing here, the plaintiff's chest was at the feet level of the person on the deck passing the rebar. So this person's passing the rebar to the first person that's hanging, and then it's getting shimmied its way to the plaintiff.
So are you saying that the two people next to him weren't standing on the solid ground?
No, they were not.
On a rebar that's thicker than?
They were standing on a piece of wood form in the rebar itself,
see.
not anything that was sticking out.
Okay,
And when
so
the
they were
plaintiff had-
still standing on something more than?
I would not
just
describe
like
it
a
as standing. I
toehold?
would say that they had some place to place their foot. If I would describe myself as
Were they
standing right
standing or
now.
not? Were they sitting?
They were hanging with their feet in front of them, placed on the form. With respect to the falling object, the rebar itself did not fall. It was still held by plaintiff's two coworkers, and only a small portion of it, of the 160-pound.
But I guess we've moved away from the falling worker, falling object dichotomy. Now it's under runner and quadrochi. The single decisive question is whether the plaintiff was exposed to a gravity-related hazard, the nature of which the devices under 240 were meant to protect.
So with respect to the gravity-related hazard, I would argue that that would apply only if it's a load that requires securing or that is expected to be secured, or one that is being hoisted. I don't believe that this single piece of rebar that was being passed.
Under quadrochi, it's an object that's hoisted or secured or requires securing.
Requires. There's testimony that this work was done in this fashion previously and the day prior. While yes,
There's also testimony that there was a hoist that could be used to do this work.
again, the fact that there was a crane there that could be used does not mean that it has to be, and that's the only way to have things done there.
So how much does this rebar weigh?
A Google search for a rebar of this type would,
So is there anything in the record in terms of this particular rebar?
no, Your Honor.
But it is clear that the rebar was heavy, is that correct?
Yes, according to the testimony.
So you're arguing that because you have 3 individuals who are hanging, using your term, because you said they weren't actually standing on anything, so they're hanging, that they should be able to bear the weight of transferring this rebar?
Well, the rebar is being passed from a person standing on the deck to these then 3 individuals there, so yes. And
So they should be able to guide it without a problem.
yes, and that was accomplished prior to the accident, the day prior to the accident, and the plaintiff was able to finish that when he dropped and caught his bar. Again, the rebar did not fall to the ground.
You just said when he dropped and caught it, so that
When he dropped his portion of the rebar, my apologies.
so if he dropped it, it's
If he
not
dropped his
falling?
portion, if it's a 25-foot piece of metal or
Right.
whatnot.
So because 3 individuals apparently were able to manage this the day before, then obviously there's no negligence here because the defendant and, the plaintiff and the 2 other individuals are unable to manage it on this particular day.
I'm sorry, could you repeat that, Your Honor?
You stated that this had been done in the past, right? In fact, the day before.
Yes.
So you're arguing that because it was done the day before without any issue, that meant that that the plaintiff was somehow negligent or should have been able to manage it on the second day because it was managed the first day?
With regard to that, I would just state that, again, there's,
I think that was kind of, no, never mind, thank you.
thank you, Your Honor.
Thank you, Your Honor. Just want to refer to three cases very, very quickly. Kyle against State, workers wearing protective devices, harnesses, and so on. They fell. It was still a 240 case. Kyle against State.
And would it have been cheaper for the construction company if they didn't use a crane, even though it would have done the work more efficiently?
Would have been cheaper for them to not use a crane?
Yes.
It would have been cheaper on them, but it would have been harder on the workers.
Yeah.
Obviously, they needed a crane, and the testimony was they had used the crane because this particular rebar, the number 11 rebar, was very heavy. The other case I went through for Montalvo, I handed the case up. It was cited before. Stands for the proposition you don't need a falling worker or a falling object to have 240. And the third case is Palumbo that came down recently after my primary case. You need a stable work platform, and that it was two pallets that were rigged together and collapsed. He wasn't even given a pallet. He wasn't given anything. He was standing on a piece of rebar. So if there's no further questions, I'll rest.
Thank you, Bob. Verini v. Inform Studios.
Good afternoon, Your Honors. May it please the court. Daniel Horner for the appellants. This is a straightforward, very simple breach of contract action concerning a contract for construction. That contract is only between Inform Studio and the respondents. None of the appellants are parties to that contract, and it was reversible error for the trial court to deny the appellant's motion to dismiss, holding that the appellants appeared to have contractual obligations to the respondents when the controlling contract was only between Inform Studio and the respondents. The respondents, to the extent that they argued that other documents that they introduced in opposition constituted contractual obligations between the appellants and the respondents, were mistaken, as none of those documents, insurance certificates, a work permit, a home improvement contractor salesperson's license.
Was there anything in the record that would support piercing a corporate veil with regard to the defendants who were not parties to the contract?
No, so the complaint only alleged very textbook breach of contract allegations, defective work, delays in completing the work, and allegations of improper billing or incorrect charges, but no abuse of the corporate form that would elevate any of those allegations beyond the realm of resolution outside of the four corners of the contract. No evidence or no allegations, I should say, that the appellants, whether through the corporate entities or Mr. Eck himself, abused the corporate form to commit those breaches of contract. Those were textbook breaches of contract to be resolved in accordance with the terms of the contract itself. And certainly—
Was there any conduct that could be colored as fraud by those other companies?
No, none that's been alleged. The respondents state that the appellants commingled funds, which I don't think is even a fraud, but they don't actually allege any harm to have resulted from the alleged commingling of funds amongst these entities. So,
Owned by Mr. Eck.
I'm sorry?
That's all owned by Mr. Eck.
Yes, that is correct. But let's say hypothetically that there was commingling of funds among these entities. There was no resulting harm that's been alleged. In other words, they can't say that subcontractors on this project went unpaid and leaned the project, or that there was some other resulting loss from the purported abuse of the corporate form.
Well, the plaintiff's sort of flying blind here, right? At this procedural posture, there's been no discovery. They're making allegations with respect to the Mr. Eck's involvement with these various entities. Presumably, they're not privy to that sort of information at this point.
That's true, Your Honor, but I think you have to look at the harm that's been alleged. And when you look at it, it really is just a textbook breach of contract. If it's defective work, their remedy is the cost to correct that defective work. If it's delays, then it's the damage that resulted from that delay. If it's overbilling, then it's the amount that they were overbilled by. But you can't look outside the contract to expand the scope of liability.
Thank you.
Good afternoon. Joanne Barini, pro se for the respondents. The
So could you pick up on your friend's, the last statements that were made? In your complaint, what is the injury? I was trying to figure out exactly how how piercing the corporate veil, or how these other entities in some way caused you injury. Exactly what is the injury?
Well, the first one I would talk about is the DOB permit.
Is the what? I'm sorry?
The DOB permit filed by Block Studios, who were responsible for maintaining the site and didn't maintain the site and withdrew equipment to keep the air going, and we had a mold problem. So that's one in and of itself. Secondly of all, the work was shut down because of the negligence of Mr. Eck and his organizations. After the work was shut down, for months, we were negotiating with the co-op to get them to restart the project. We finally, after months, get them to restart the project. And on June 7th, Mr. X said that he could restart on June 17th, substantial completion by October 19th. 3 days later, after that information was forwarded to the co-op board, we get an extortionate letter with a contract addendum from Mr. McGuire, dated June 10th, and it's in the record.
Who's McGuire?
He was a lawyer that we didn't know at the time.
Representing whom?
Mr. Eck, apparently, demanding all these extortionate things, or Mr. Eck would not start work on the 17th of June. And had he started work when he said to, he would have been done on October. And because of that bad act, we went into the COVID. That project went into
So all of this seems to be just, I want to say basic, but things that occur when you have a contract for renovations. I'm not understanding in terms of what's set forth in your complaint as to how this would lead to any determination as to fraud, et cetera, which would lead to piercing the corporate veil.
So fraud isn't required. It's dominance with a consequent wrong, okay? And we've set forth a laundry list of consequent wrongs. Also, they just want you to look at the complaint. That is not what the law says. You can look at the totality of the evidence to determine if we've met a prima facie case prior to discovery. And they have a bunch of Insight Services lays out the framework. In terms of piercing the corporate veil, they're co-located, same employees. They work on each other's projects. He used these entities interchangeably during the course of the Barini renovation for his own purposes. He issued certificates of insurance on behalf of Inform installers, all sorts of things that were done that would pierce the corporate, that goes through the Insight standards of what's required here.
Thank you.
Okay.
So briefly in response to that, I would just say that, even assuming that everything that has been argued is correct and that Mr. Eck used these entities interchangeably, there was no benefit that's been alleged. He didn't misuse those corporate entities to gain in any way. The breaches that have been alleged, the harms, are still the very same harms that would have resulted had these entities not been used interchangeably, or had they. It doesn't matter, because the damages are the cost to correct defective work, or the resulting damages from delay, or the amount that they were overcharged. So I don't think that the respondents have met their heavy burden of disregarding the corporate form, and certainly imposing any personal liability on Mr. Eck himself, by virtue of the allegations that have been made.
Thank you. Thank you both.
Thank you, Your Honor.
People v. Corey Key. Yes.
Good afternoon, Your Honors. Graham Ball of the Legal Aid Society on behalf of Corey Key. There are two issues in this appeal, but I would like to use my time to address the retention issue today. This case should have been sent to family court because there are no extraordinary circumstances sufficient to overrule.
How do we know that? And the reason I ask you that is, how do we define extraordinary circumstances under the raise the age?
So we've outlined in our brief several ways that this court can look at it, looking at the plain dictionary definitions of extraordinary circumstances, as several courts have, looking to the legislative intent, and looking to the purpose of this law. And the
Can
purpose.
you raise your mic? Closer.
Oh, I'm sorry. That's not good. Thank you. The purpose of this law, which is to send the over.
Raise the mic so you don't have to bend over. It'll go up. Yeah.
How's that?
Yeah.
Okay, thank you. And the purpose of this law, which is to send the overwhelming bulk of cases to family court. The legislature contemplated that only truly serious cases, those 1 in 1,000 where the prosecution proves both.
I know you make that argument in your papers and you lay that out, but in looking at the cases that have dealt with it, there seems to be, some friction, or it's kind of unclear as to exactly what extraordinary circumstances means.
I think an excellent example for this court is the Second Department's recent decision in People versus Lloyd F. That case meticulously dissected the extraordinary circumstances standard with a case involving very similar facts. Lloyd F. was a 16-year-old convicted of the same offense that Corey was convicted of in this case. Lloyd F. had a youthful offender adjudication for a completed first-degree assault from when he was a 14-year-old. Corey has a youthful offender adjudication from when he was a 14-year-old for an attempted first-degree assault. That court held very powerfully that under any reasonable interpretation of extraordinary circumstances, those facts did not meet
I
the
thought
standard.
Mr. Key's first YO, or first adjudication, was for shooting into a crowd of individuals. Is that correct? Firing a weapon into a crowd of individuals. Was that not the first?
That was he was adjudicated. So that was what the arrest was for. He engaged in services for the next 2 years, and he was afforded the opportunity to earn a youthful offender status.
Right.
Youthful offender status is a judicial determination.
I think we're all aware of what a YO is. So that was the first adjudication, was for discharging the weapon into a crowd of people. And now we have the second, now we have this case wherein he is arrested and charged with possession of a weapon, I think with the intent to use unlawfully, I'm not sure. Yes, CPW 2. Again, he did not use that weapon. So isn't that a little different from the case that you just mentioned, Lloyd F.?
Lloyd F., his prior youthful offender adjudication was for a first-degree assault. If there's a youthful offender, the case does not discuss the facts underlying that first-degree assault, but if it's a first-degree assault, there has to be significant physical injury. Here, it was equally serious. It was an attempted first-degree assault, but if we would be dicing the onion very thinly
Counsel,
to say.
why isn't this case more similar to a case out of this department, People versus Messina?
I think People versus Messina is as far away as it gets. I know 3 justices of this court.
I'm sorry, I didn't hear.
I think People versus Messina is extremely different. That case involved a youth charged under 3 different indictments. On the first indictment, he was charged with an attempted gang assault. I believe there was significant physical injury in that case. There was a stabbing, so as to categorically preclude his removal to family court. The second case in which this court found extraordinary circumstances, there was a concurrence in which Two justices found it was inappropriate to deal with that issue, but that case was an attempted robbery in the first degree, and the court held that a substantial aggravating factor was that he committed the offense while under supervision. Here, Mr. Key did not cause significant physical injury to anyone in either case. His prior case, he discharged a gun, but no one was injured. In this case, he
It was lucky that no one was injured when you discharge a weapon into a crowd of 7 individuals. It's, you know,
it was
lucky that none of the 7 individuals were injured.
It's-
What about People v. Guerrero?
that is currently being argued today.
It might be being argued as we speak.
As we speak, it's possible, Your Honor. Yes,
And so in that particular case, it's a Fourth Department case, I think?
it's a Fourth Department case.
And it deals with, or it is addressing the issue of what constitutes an extraordinary circumstance, right?
Yes, you know, I don't think that the Court of Appeals is going to reach the legislative history and find something different that the Second Department didn't find. But that case, again, involves drastically different facts. It's a home invasion in which the child in that case used a shotgun to pistol whip someone as he slept.
The underpinning of all of these cases is that the individual had received services, and the argument is that they didn't benefit from those services, or they wouldn't benefit from additional services by sending the case to family court. And that lays the groundwork for finding that there is extraordinary circumstances to keep the youthful offender.
I disagree again as to in terms of amenability, because I think if the statute was solely focused with amenability, it could have been drafted that way, but it used the term extraordinary circumstances. So extraordinary circumstances is plural. If the legislature meant it to be whether or not a kid was going to benefit from family court services, it could have said that factor alone. But Guerrero is different because that adolescent offender had 8 prior contacts with the system, 8 family court appearance tickets, and 2 juvenile delinquencies. Here we have 1 rearrest, which is very
extraordinary that a youth might make a misstep in the course of participating in a rehabilitative class?
Absolutely not. And I do not think, you know, the reason, and that's why I would keep going back to the purpose of this law. Again, the overarching consideration is that the overwhelming bulk of cases be transferred. And the reason we have this law is the recognition that children are going to make mistakes over and over and over again, and we don't want to burden them with this.
And so at what point in time do we say enough is enough?
It's a very good question, and that's not one that has been resolved, and I don't think you need to resolve that in this appeal because it certainly is more than a one strike you're out.
Would you agree that the determination whether to retain a case in adult court or send it to family court is a discretionary one?
It's discretionary, and that's another issue I think that needs to be resolved, because if you look at Guerrero in the majority, it says that the trial court did not abuse its discretion because the prosecution proved extraordinary circumstances. In Lloyd F., it said that it looked at the record, right? On this record, there were no extraordinary circumstances. In another case,
And so here in our case, we have a trial judge who looked at the record, gave us a written decision, not some brief conclusory order, but a reasoned decision. We can disagree with the conclusion, but afforded us the benefit of his analysis. And so how does that play into the discretionary element here? Do we have to give deference, or should we give deference to the trial judge's finding here?
I don't think you need to give deference in this case. I think the question, again, the statute is drafted in terms of the prosecution establishing a burden, right? They have to prove extraordinary circumstances. And here, you know, we keep going back to his engagement in services. The written decision expressly commends him for his performance in services. Throughout the pendency of this case, he graduated from high school, at which sentencing he was commended a second time. And the judge, page 5 of the sentencing transcript, characterizes the offense as serious foolishness, which is exactly the type of conduct that family court should address. It's not, and then again...
But again, we have a situation where we have him in possession of a weapon, discharging that weapon, and now we have a second situation where he again is in possession of a loaded weapon. So why would we not then defer to the discretion of the trial court in stating, I considered this, and given the people's presentation and given the facts of this particular case, I'm not going to transfer the case to family court.
So the statute, I understand your Honor's reservation about gun cases. The fact that there are 2 gun cases doesn't mean the court is entitled to any more deference than it would in another case when it's not
In
guns.
the second case, it's not just that he's carrying the gun. He was stopped from choking another young person.
He was charged with a misdemeanor assault, and if that was the only charge that he was facing, it would have started off in family court. It wouldn't even started off in the youth part.
But it was not. It was coupled with the fact that he's in possession of this weapon. And I think at some point, this is where he attempted to say that his sister was the person who, the bystander, that it was the bystander
I don't.
who had the weapon. You have time on rebuttal.
Okay.
Good afternoon. May it please the court, Catherine Murata for the people. The court properly exercised its discretion in finding that extraordinary circumstances
So
exist.
given the legislation, should there be a presumption that these cases should be transferred to family court? And I guess a rebuttable presumption, right? So we presume that it's going to be transferred to family court, and then the people just have to rebut that presumption and show why it should not be transferred to family court.
So yes, the majority of cases are intended to go to family court from the youth part, and the people can either show by 2 different ways that there's a 3 prongs that they can satisfy physical injury, that he's displayed a loaded firearm, or sexual misconduct. If they satisfy one of those factors by preponderance of the evidence, then it is retained in Supreme Court. And then if none of those factors are found, then the people can file an extraordinary circumstances motion, which was
So what is extraordinary in this situation, in this case?
So, although the statute doesn't, define what extraordinary circumstances is, we can look at the dictionary definition. And also, the test pretty much is they're determined by the judge looking at the record and the totality of the circumstances of the defendant of the case, and weighing the factors, the aggravating factors with the mitigating factors. And
So in this, go ahead.
The extraordinary circumstance is not a scenario where the people are not able to prove those other statutory factors, so you just bring in extraordinary circumstances and then you're entitled to retain a case. You have to actually prove something, correct?
Yes, we have to file a motion kind of showing.
What was extraordinary in this case? What rose to the level of extraordinary?
So I think it's a variety of things. It's not just the crime itself, but it's his defendant's previous YO adjudication and the underlying facts of that. He did fire a gun at a group of individuals, and unlike the defendant in Lloyd F., defendant was the primary actor in both his YO offense and his current offense. He did harm someone with his 3rd-degree assault by throwing and choking the victim down to the ground. He did
the misdemeanor that would have automatically gone to family court, right?
Correct, but that's just another reason.
But how
that someone was harmed.
Misdemeanor assault that would have on its own just gone to family court be part of an argument for extraordinary circumstances?
It's just another difference between this and Lloyd F. In Lloyd F., the court relied that no one was harmed. Here, I just want to say that someone else was harmed beyond the gun possession. But in any event, the defendant did fire at a group of individuals in his previous case, and here he did possess a loaded firearm at a crowded basketball game in broad daylight.
So in your argument, in terms of determining what constitutes extraordinary circumstance, we're also looking at the facts of previous cases, or are we looking at what actually happened in the case before the court to determine whether that is an extraordinary circumstance that requires retaining the case?
I think it's a combination. I think it's the details of the current offense in conjunction with also his previous criminal history to show that he was adjudicated a YO, and mere 7 months later, after receiving services, he's committing this offense only 7 months later. So I think that kind of sheds light on the current offense as well.
There isn't much in the way of legislative history, right? The Raise the Age Act was part of, I think, part of the budget, and therefore there wouldn't usually be a bill jacket. We do have, I think, Assemblyman Lentol's discussions on the floor, and there I thought he said that what we're looking for is a set of heinous facts, highly unusual facts. This may be a sad commentary, but is it highly unusual that a youth within the city of New York would unlawfully possess a firearm multiple times?
I think as to the unusual or heinous facts of the crime, is only the Joseph Lentol said that was just a guidepost, that wasn't a strict prong that had to be satisfied. That was just one consideration for.
Right, but where something's not defined, right, we have to look at things that present guideposts.
True, and I do think that the heinous crimes is one consideration here, but I think here, given, if we look at the totality of the circumstances, which is the standard, the judge carefully reviewed, and his decision is as well reasoned. He detailed the reoffense with the gun possession, but also that despite receiving services, this defendant, he knew that the one thing he couldn't do was reoffend, but after these services, 7 months later, he's already, reoffending.
But again, is reoffending extraordinary?
I think reoffending.
Should we define reoffense as a factor in something being an extraordinary circumstance that retains a case in adult court?
I think just given, the totality, his first offense, he was the primary actor. He fired at a group of individuals. That could have almost been, that could have escalated here.
But the court's analysis on what caused the court to determine that there was extraordinary circumstances geared more around him having been involved in services and then reoffended. Not really much of a full analysis about the other offense.
Well, the amenable to services is another guidepost for the youth part judges to evaluate. And here he did have over a year of services between the plea and sentencing, and obviously he was engaging in the program, but his actions shortly after the programming ended just showed that he was not amenable. His conduct proved himself not amenable to the services.
So the service providers thought he was doing a good job. Is your position that if a young person engages in services, attends and is thought well of by the service providers, but once again commits a criminal act, that's enough to constitute extraordinary circumstances?
I think that's, again, a consideration as part of the totality of circumstances, that he received this programming. Even if he did well, obviously they didn't, have a benefit ultimately, because within 6-7 months he's reoffending. So I think that is a consideration.
Well, the benefit of the services would be, how did those services inform future conduct?
Correct, and his future conduct, despite these services, he is continuing to commit crimes. And
but that's not cut both ways, because then you could state that, it was only 7 months, and so if he were to engage in services in the future, it would in fact inform his behavior.
I mean, there's no indication.
Meaning, did we give him was he given enough of an opportunity to take advantage of those services and be informed by those services?
I mean, I believe so. He was doing multiple different programs for over a year. He was engaging and doing well, but the fact of the matter is he had to have known, if you're doing well, that the one thing you can't do is reoffend, and then he immediately almost reoffends. Again, it's the difference between this case and a Lloyd F. is Lloyd F. He's sitting in a room smoking marijuana and pointing his gun at the computer. Here, he's actively bringing a loaded firearm that had seven cartridges in the magazine and one in the chamber. He's bringing that to a crowded basketball game in daylight, where those things could have, that a high potential for danger could have escalated.
Drawing on your experience with these raise the age cases, is this that 1 in 1,000 case, to paraphrase Assemblyman Lentol, that should be retained?
Yes, I believe it should be retained. The 1 in 1,000 language from Lentol also is not a strict standard. It's just another guidepost. But I think ultimately the standard is determined by the judge's evaluation of the record and totality of their circumstances. And here, Justice Ancinani carefully weighed the factors. His decision's well reasoned. he took into account all the totality of circumstances and determined that there was extraordinary circumstances here. So I think ultimately the judge did not abuse his discretion in determining that there was extraordinary circumstances. Thank you.
So, Your Honor, Lloyd F. Expressly found that the mere fact that an adolescent engages in rehabilitative services and is later rearrested is not strong proof, right? That's the other thing, is it's strong proof of amenability, that he or she is beyond the reach of the family court system. And so I don't know how we can meaningfully distinguish what the court did in the second department from what's happened here. We have my client is arrested.
Well, your client had completed services on the first case, right?
He did.
So he fully engaged with those services.
Mm-hmm. Yes, and so then I don't understand how that question distinguishes Messina, which is, it's an aggravating factor because he offended while he was receiving services. It sounds like that question is saying, regardless of whether you're on services or not, it doesn't matter.
I thought, well, okay.
So I think that there's no meaningful difference here between this decision and Lloyd F. Lloyd F., maybe he brought a firearm into a basketball tournament. The basketball court was at the NYCHA development that he lived at. Maybe it's a bit more serious. But that, cutting these distinctions when the standard is so high for the prosecution, it makes this really complicated. I think you can put this...
What deference do we give the trial court in its discretion, given that the trial court is presiding over these cases?
Mm-hmm. I think your obligation here is to look at the record and assess whether the prosecution proved extraordinary circumstances. If you can identify the extraordinary circumstance, you can look to the judge's decision and say, did he exercise his discretion, he or she exercised his discretion in granting the motion? But if the prosecution failed to prove an extraordinary circumstance, granting the motion is an abuse of discretion.
And your position as to why the prosecution failed or did not prove extraordinary circumstances is because what?
I think if you were to find extraordinary circumstance merely because a child engages in services and rearrest, that would totally frustrate the point of this law. How many times are you going to have a child in the youth part who has a prior contact with the system? Again, that would frustrate the purpose, which is to send the overwhelming bulk, 999 of 1,000, or whatever you want to.
So in your estimation, extraordinary circumstances would essentially become a catch-all, right, for the prosecutors?
I think in this case, this is a catch-all, right? The statute says significant physical injury is one category of cases that prevent removal. Displayed a firearm, and Lloyd F. looks at that and says, well, by narrowing the category of cases to displayed firearms, possession cases must have contemplated to been removed. This is a possession case, and then you have sex offense cases.
And in this case, Corey Key did not show the firearm when he was at the basketball event, right?
He did not show it. He was not accused of it. And the complaining witness, she was also arrested in this matter. She was arrested for a second degree.
And people who carry weapons don't carry weapons with the intent to use them. They just carry weapons to have them in their possession.
It's a
Thank you very much.
Thank you.
Lifka v. Paul Weiss. Yes, please proceed.
Good afternoon, Your Honor. Your Honors, may it please the Court. My name is Jim Bonner. I represent the plaintiffs in this shareholder derivative action, Randy Slifka and David Dove. While the Supreme Court granted the motion to dismiss in this case, there's no question that the defendants committed egregious malpractice. That is outlined in a scathing arbitration award that was documented the ethical breaches that the defendants committed, as well as the damage that they did to the two nominal defendants in the case, who my clients seek to represent.
But the decision that Justice Crane made was based on the fact that her view that the plaintiffs didn't have appropriate standing to represent the nominal defendants. Can you address that, please?
So one reason why Justice Crane decided that they didn't have standing was that there had been a release signed by Barbara Slifka, who was the former manager of the two nominal defendants.
How did that affect the plaintiffs' standing to represent the nominal defendants?
Well, she ruled that the nominal defendants did not have a case anymore because Barbara Slifka, who was the manager of the two defendants, had released those claims.
Well, let's just say, let's assume for a second that we agree with you that as to Barbara, the release was void or unenforceable. What impact would that have on the conflict analysis as it relates to Michael and David? So if Michael and David, the release and the indemnification provisions remained in force as against them, would there still be that conflict between the plaintiffs and the nominal defendants?
I think no, Your Honor. And I think before we address the specific language of the indemnification provision, it's very important to note that Paul Weiss and its very esteemed counsel in this case filed 2 briefs in the Supreme Court with respect to the motion to dismiss. Neither one of them, not one word in either one of those briefs regarding this indemnification issue. And I say that not to say they waived it, because eventually that will come up in the course of the case. But we have one of the most sophisticated law firms in the world and a very, very esteemed counsel representing them in the case, and neither one of those entities saw any indemnification obligation until the day before oral argument in the Supreme Court, when they said, oh, we found this magically in the agreements. And I think, Your Honor, the reason why they didn't point out this indemnification issue in the Supreme Court is not because of any negligence on behalf of Paul Weiss or its counsel. What it was nobody intended at the point in time at which these settlement agreements were entered into that the brothers' trusts, Michael and David, would indemnify Paul Weiss for conduct that was undertaken by Randy Slifka and David Dove, the plaintiffs in this case, people they had absolutely no control over. So no one intended that. And we can tell that because the key language that's in the indemnification term says they will agree to indemnify for claims that are pursued by or on behalf of the trusts. That's the brothers' trusts. So this case is pursued by Randy Slifka, David Dove, and it's pursued on behalf of the nominal defendants in this case, the 2 Mad Ave associate entities. It's a shareholder derivative action. So they don't satisfy either one of those criteria. It's not pursued by the brothers' trust, and it's not pursued on behalf of the brothers' trust. It's very explicitly being pursued on behalf of those 2 entities, the Mad Ave Associates and Mad Ave Holdings entities.
Wouldn't that affect both David and Michael, because they have a separate settlement agreement? And if they were to indemnify under that Paul Weiss, then they would be prejudiced.
Indeed, Your Honor, if they did have an indemnification obligation, they'd be prejudiced. Counsel would have to be paid, et cetera. And if there were a judgment entered in the case, then they would have this indemnification obligation. But my point is, and I wasn't sufficiently clear, is that they have no indemnification obligation. They have an indemnification obligation only if the case is brought by them or it's pursued on behalf of them. And neither one of those criteria are satisfied here. Brought by.
The latter isn't satisfied by virtue of this being a derivative action?
That's absolutely the case, Your Honor, because it's very clear, and there's a lot of circumstances in which this issue has to be closely considered. There's a difference between direct claims that people bring on their own behalf and derivative claims that they bring on behalf of entities. And so it affects demand issues, it affects whether you have a right to come to court as a shareholder and bring a claim, et cetera. And if you were to say that every case that's brought derivatively is actually brought on behalf of individual shareholders, then you would be upsetting centuries of case law regarding that issue.
If we can get back to the release, which David and Michael, they were a party to that release, were they not? And they were represented by counsel?
They were indeed, Your Honor, but their release, and there's no question in this case that their release had no ability to release the claims of the 2 entities. Barbara was the sole manager of the 2 entities, the only person who was empowered by law and under the terms of the agreements to release the claims that are at issue here. So,
but the release specifically stated that it included all actions, including derivative actions.
Barbara's release, but that's why our number 1 point, Your Honor, is that release is totally invalid. And the reason for that is that...
Was that not also included in the release signed by Michael and David?
Totally irrelevant, though, here, Your Honor, because though.
Why is it irrelevant where the release specifically states that it includes derivative actions?
They're individual shareholders, Your Honor. What we're doing in a shareholder derivative case is stepping into the shoes of the corporation and the partnership that are involved here.
Which are Michael and David, because they have interests under the, what is it, Moldev Associates.
No, Your Honor, the case law is clear that the individual shareholders of a company or a partner of a partnership, they have no right to do anything on behalf of the partnership. And certainly they don't have the right to release claims, and no one's claiming otherwise. It's very clear in the organizational documents for these two entities that the only person who had the power to operate these entities, and therefore the only person who had the ability to release the claims that were at issue, was Barbara Slifka.
So in your view, the derivative action a derivative action necessarily is brought on behalf of an entity.
Correct.
The indemnification provisions here, as they relate to Michael and David, only apply where the action is brought on their behalf in their individual capacities.
Correct, Your Honor.
So therefore, this particular action wouldn't fall within the ambit of the derivative, the consequences of a derivative action.
Correct, Your Honor. Again, and it
That's
gets.
based on what?
It's the language of the indemnification provision, Your Honor. Again, the language says that they're only agreeing to indemnify, and this is what someone would expect. Would you expect somebody to?
The language of the indemnification clause states.
It says pursued by. It's not pursued by David or his brother, right? Not pursued by them. Pursued on behalf of. It's not pursued on behalf of them. The shareholder derivative case is pursued on behalf of the entities, not individual shareholders. If I am a shareholder of Apple, and Apple has a lawsuit.
So again, under your analysis, David and Michael would not be able to bring suit.
Well, they could bring suit in a derivative capacity if they didn't have a release that they had signed.
I see.
But
Thank you.
I have another question. So, as I understand Justice Crane's decision, her decision really turned on her view that Randy and David Dove did not have standing to represent the nominal defendants. Can you address that?
Again, I think standing has multiple factors here. Number one is that a release had been signed, so nobody could bring a claim according.
I'm sorry?
The release that Barbara Slifka signed as the manager of those two entities, I think Justice Crane found you don't have standing because you've already released those claims. You can't bring a claim that's already been released. And yes,
Specifically we're addressing Michael and David.
No, Randy and David.
Excuse me?
Go ahead.
Continue, I'm sorry.
Okay, very, very briefly about Barbara Slifka's release, okay? She signed this release, she's 90.
I thought you were, I'm sorry, you were answering Justice Gesman's
Right, I
question.
want you to address whether or not the plaintiffs have standing to represent the nominal defendants.
They have standing, Your Honor. They're shareholders or partners in these two entities.
But Justice Crane found they didn't have standing, and can you explain why you disagree with that?
Again, I think that she thought that the claims had been released. That was number one. And so that's incorrect for the reasons that we outline in our brief. So we do have standing as a result of that. And then she also got into whether there were conflicts or whether this indemnification provision that we've been discussing somehow or other would prevent them from bringing the claims. And I think that was an element of the standing analysis that she undertook as well.
Thank you.
I'm sorry,
You
Your
have
Honor?
time on rebuttal.
Okay, thank you.
Eric Seiler, Freeman Kaplan for the respondents. Justice Crane did not rely on the release in deciding that there was no standing to bring the derivative claim. She identified the precedent in this court, the Calico case, and said, look at the totality of the circumstances. And then she noticed the complete non-alignment between Randy, who wanted to bring the case, and David and Michael, who had settled the claims for less money, released the claims, and even if there was no indemnity, they wouldn't be aligned. And then, but also indemnified for the very claims here. And so she identified that complete.
Sorry, sir, but are they the same claims here? If I'm understanding your friend's argument, this is a derivative action which necessarily the plaintiffs are are asserting against the corporation, and they have and the nominal defendants are part of this, but not the individuals who may have an interest in those nominal defendants.
So let's look at the nature of the nominal defendant, because not all corporations are the same. This is a pass-through. Originally, it was a pass-through that owned some land. They sold the land. Then it becomes a pass-through that gave out the money, they said, in the arbitration incorrectly, and they adjudicated that. By the way, that arbitration could have been brought derivatively on behalf of everyone. It wasn't. Why weren't they forced to bring it derivatively? Because it's a pass-through. We knew the answer. What would happen to the money that goes to the corporation? It immediately gets divided up. In fact, in the record, in this case, it says it's pro rata. So
Right,
if you were to allow this case to go...
I thought it was Michael and David who received the monies under the Maldive Associates.
So they each got $8 million because they settled before the arbitration was over and released their claims. Randy got the full $21 million, which was his 1/6. That's what happened. If more money comes into them because you allow these claims to go forward, he's going to get more money. He's going to get another 1/6, even though he was paid 100% of his share of what the arbitration panel said should have been paid originally.
Well, and then Michael and David, their monies would have to go back into the estate.
Well, in fact, Justice Crane identified that maybe Randy should be suing himself to put the money back into the estate. She said that in the oral argument. For the same reason, he was fully paid, and they got what they wanted, and then they did give that indemnity. And I just think that if you look at the case, the Jacob versus Gershwin case, which was in the New York County Supreme, looked at the fact that the other shareholders didn't want to participate. And this is different from a case where, in a derivative case, where you're suing a bad actor owner or a bad actor manager. That's why I said not every corporation is the same. It's not Apple.
Well, Michael and David Dove did not want to, Michael and David did not want to take part in this because What is the significance in your mind, or in terms of your argument, as to the fact that the release as to Barbara was invalid? How does that affect the release as to David and Michael?
Well, I don't think the release as to Barbara was
well, Justice Crane stated.
She didn't say that either. But she did say, and they admitted, there's no challenge to the releases from the siblings. They had Proskauer and another big law firm represented them. They did it knowingly. They got the money. He does not challenge those releases. He challenges my interpretation of the indemnity. But I say to you, under Jacob versus Gershwin, even if there was no indemnity, they'd be misaligned.
So if we found that the release as to Barbara was invalid, does that in any way affect the releases as to Michael and David?
Not at all. Not only doesn't it affect the releases, it doesn't affect the indemnity they gave. And coming back to your question, the indemnity covers any claim that could have been brought by a releasing party. The releasing party, because of Barbara, included these nominal defendants. They're all releasing parties. And it says by or on behalf of. We have to give meaning to the words on behalf of. And on behalf of is for the benefit of. And if he wins this case, money is going to go to Randy, Michael, and David. They're going to benefit from it, and so they're indemnifying it. And for them, it's going to be, at best, a circle. Money's going to come in from Paul Weiss, and then they're going to have to pay it back to Paul Weiss if the indemnity applies. And they might have to pay it to Paul Weiss for the share that Randall gets.
But only if the indemnity clause is valid.
Sorry?
Only if the indemnity clause is valid.
Only if the indemnity clause is valid. But he's claiming that the indemnity clause doesn't apply. It's confusing. And we cited cases that say even if there's a fight about the indemnity, that still makes Randy misaligned with Michael and David. Randy wants to bring the case, and they don't want to bring the case. Now they're going to have to defend whether or not this indemnity applies or not. And that's why he's not a proper plaintiff, which was the core of the complaint. Also, all of these, I'll say one more thing as I'm running out of time, all of these claims are time barred. Justice Crane didn't need to reach that, but these are 3-year claims. They're for money damages only. There's no case all the cases that say derivative claims are 6 years are because there was equitable relief being sought. This is purely money damages. It's 3 years. And the continuing representation exception doesn't apply to Randy. He's hated Paul Weiss from the case this court already decided letting him sell the property. So there's no continuing representation defense. And so if you have trouble affirming for the reasons that Justice Crane ruled in our favor, you should reach the statute of limitations. It doesn't need to be remanded. It's straight law and applies to the cases here. We raised it below. We raised it here. So
Thank you.
Thank you, Your Honor.
Your Honors, as to the conflict issue that my esteemed opponent raised, it's a very high burden in a derivative case to have a case dismissed as a result of a conflict among the owners of the entity. And what the court has said in the NWM capital cases, there has to be evidence that the plaintiffs are not pursuing the case for the benefit of the entities. And there's no evidence of that at all here. Even Mr.
Counsel, does the fact that this is a sort of a pass-through entity, as your opponent said, matter in the analysis at all?
It doesn't matter here at all, Your Honor. So any partnership would be a pass-through entity. And as a result, there's always going to be a fact that the owners of the partnership are going to get the proceeds of a case. But that doesn't eliminate their standing to bring the claim. And it certainly doesn't create a conflict. And what this court has also said in the Alt case that we cited is that the mere fact that others are sitting on the sideline and they're not pursuing a claim doesn't create any kind of conflict. So here, the two brothers, they'll be perfectly happy when we win this case and we're able to collect these additional funds.
Michael and David?
Michael and David, the money will come
Why would
in.
they be happy? They would have to give back the monies, and they may now get less money.
That's absolutely incorrect, Your Honor.
That they would have to give back the monies?
That would only be if the indemnification terms were provided. And in my principal argument, we made that point that they have no indemnification obligation here. They didn't bring this claim, the brothers, and they didn't, and it's not being brought on behalf of them. And so there is no indemnification obligation at the end of the day. And so there is no conflict. This conflict that's being brought up here is totally imaginary. What's going to happen here is when we win this case, this money is going to go to the partnerships and it's going to be distributed to the partners. Paul Weiss has no interest in that. It's none of their business how the money gets distributed. But that money, everybody
So Randy gets more money, is that correct?
Also, Your Honor, Randy will get more money, but another thing that was neglected
And
here-
Michael and David would get less money, perhaps, yes?
No, they'll get their share. They're all equity owners.
Which may be less, right?
Well, they all own the same percentage of the entity, Your Honor.
But
So
if they have to do the indemnification, if it's deemed valid, they would be getting less.
Well, if they had an indemnification obligation, that's an issue of law that the court has to decide.
Right, but you're assuming that they would not be bound by the indemnification clause.
They're not for the reasons that I've talked about here. It's a very specific contract. It says when they have indemnification obligations, and they don't here. Very briefly, because this is an important issue, the claim that we don't have any damages. Number one, there were millions and millions of dollars paid to Paul Weiss for no reason whatsoever, because they created this allocation problem, and then they fought an arbitration tooth and nail for years in order to try.
Was this part of this case wherein you went after Paul Weiss for damages?
Exactly, that's part of our damages, Your Honor, is the millions of dollars in fees that were paid to Paul Weiss. And on top of that,
But I was asking, is that part of this appeal? I did not see that.
yes, it's highlighted in the portion of our briefs that talk about whether there are damages here. That's the Supreme Court's analysis with respect to damages. And I think just one point in closing that's very important to make is that the idea that there are no damages is defeated by very simple arithmetic. Randy got $16 million as a result of the arbitration. The two brothers, for whatever reasons, decided that they were going to settle for less than half of that. So they've received less than half of that amount for their interest in the two entities. And what we know is on the other side of the allocation, the real estate fund Shorenstein Partners walked away with tens of millions of dollars that belong to the two entities that my clients seek to represent here. So the idea that there are no damages is totally false, and it's just basic math that says that there are substantial damages here in this case.
Thank you both.
Thank you, Your Honor.
Last case for argument is Peck v. Milbank.
Thank you, Your Honors.
Courtney has a few minutes, isn't it?
Oh, I'm sorry. Did I miss Courtney?
Yeah, it is a few minutes, I thought.
Oh, I'm sorry, yes, Watson v. Roanoke Island. My apologies. Watson? Oh.
May it please the court. My name is Pearl Zaklevsky, and I represent the appellant William Ivy Long. In the absence of the appellee's appearance here, unless the court has questions, I'm prepared to submit to the court.
Any questions? Matter submitted. Thank you.
Thank you, Your Honor.
Peck v. Milbank.
May it please the court. I'm Matthew Press of Press Corral LLP on behalf of the appellants. First of all, I'd like to thank the court for granting oral argument in a non-enumerated matter. I appreciate that. Your Honor, under this...
Well, this is Peck 3, so, you know, we might as well. This is the third time we're hearing this case, so why not?
Well, it's a different permutation of the case, Your Honor.
Okay.
The plaintiff's proposed Second Amendment complaint amply alleged a cause of action for breach of fiduciary duty against the defendants Milbank and Georgiana Slade. Nevertheless, the trial court granted defendants motion to dismiss on 2 grounds. Okay, the first ground was that the breach of fiduciary duty claim was somehow duplicative of the judiciary law.
We're dealing with a motion to dismiss here. The motion that's at issue is a motion for leave to file a second amended complaint.
You're correct, Your Honor. I'm sorry.
I would prefer that you address that, especially because that's a motion that the trial judge has discretion over.
Your Honor, you're absolutely correct.
The question is there an abuse of discretion here?
Correct, Your Honor. And as I cited in my cases, there's case law of this court that says it would be an abuse of discretion for a trial court to deny leave to file a well-pled amended complaint absent a prejudice or surprise. Okay, and there's no allegation by Milbank that there's any surprise or prejudice. It's the question simply on this appeal. I would contend is the sufficiency of the complaint. It's the equivalent of a decision on a motion to dismiss. But Your Honor, even if on any standard, the case clearly is not, the breach of fiduciary duty claims clearly is not in any way duplicative of the cause of action for under Judiciary Law 47. Okay, the breach of fiduciary duty claim is based on a fiduciary relationship.
So one of the issues is that somehow the executor was coerced into undertaking specific actions. So where in the complaint, your proposed amended complaint, do you state what the defendants did or that the estate representative took any unreasonable course of action?
Okay, so Your Honor, what the complaint alleges, very in great detail, is that the Slade family, Jarvis Slade and Georgiana Slade as well, had tens of millions of dollars worth of shared co-investments with the Peck family, and that she had the Jarvis Slade, who was 90 years old or so and was close to passing away, had a strong animus shared by Georgiana Slade against Ian Peck and did not want Ian Peck to be involved in those co-investments.
So what exactly did the defendants do in relation to Ms. Slade, or to Ms. Slade, excuse me, in relation to the executor in order to take that course of action, the estate representative?
It's very, very simple, Your Honor. The attorneys for Lillian Peck put their thumbs on the scale and caused her to take actions that were in their own interest.
How? What did they do?
I'm so glad you asked this question. It's a lower ticket item, but I think it's something that will help point this out to you and make clear that these are true allegations. Okay, the conversion of that 5% profit share interest into a direct interest in Horseneck LLC, that is something that did not in any way serve the interest of the estate of Norman Peck. This was a very weird and unusual profit share interest that didn't confer the Slade family any of the normal powers of a member of an LLC. And Georgiana Slade somehow manipulated Lillian Peck into agreeing to convert this interest into a direct interest in LLC, which would give them all the rights under the operating agreement and the rights to sue and all the other things. And just ask yourself, Your Honors, why would somebody do that? There was no consideration for that. That was something that clearly served...
And you just stated, you said Georgiana Slade somehow manipulated.
Yes.
How did she manipulate? That's what that I'm trying to get at. What are the specific allegations as to how she manipulated her to do
Your Honor, I don't believe that it's necessary to have those specific allegations at this stage. This is a complaint. This is a before discovery was taken on these things. All we know is it did happen, and it's something that clearly was not something that served the interests of the estate. Same, the note cases were brought that that did not serve the interests of the estate. In the 2016 amendment to Norman Peck's trust, he decided that the notes that had been issued by Ian Peck would be resolved
Yes,
by
but
an
again,
offset.
as to the note cases, where in the complaint do you state as to how it was unreasonable for the estate to take that course of action in terms of going after the payment of the notes?
Mr. Weber, I'm so glad you asked this question because I believe you were on the panel that found that there were tribal issues of fact that the note action violated Norman Peck's testamentary intent. And so what this action says is that yes, the note actions violated testamentary intent. We intend to prove that at trial, and that the reason this occurred was because Georgiana Slade and defendants were pursuing their own separate interest, which was separate and apart from the interests of the estate. There was an undisclosed animus, and there were strong financial interests that the defendants had in pushing Ian out of those deals. And what the court did is the court said, it looks like Ms. Peck knew about it, so no harm, no foul. And what I really want, if I leave this room without convincing the court of anything else, okay, it will be this. If the court allows that decision to stand, that will give a free hand to any attorney that has a clear financial conflict to go and do whatever they want to do, as long as that client kind of knows about the facts, okay? The kind of knows about the conflict. That's not the standard. The Rule 1.7a of the Rules of Professional Conduct and decisions of the Court of Appeals of New York state unequivocally that a lawyer must not take on a representation.
Is there any allegation that Georgiana Slade, in fact, knew that she would inherit the shared investment from her
Yes,
father?
Your Honor. Okay, and this is one of the reasons why I'm so glad you asked that question. In the
It's
prior
the third
appeal,
question that you gave me prompts on. Thank you.
in the prior appeal that we had a couple months ago was based on the First Amendment complaint. And with all due respect, I believe the First Amendment complaint sufficiently alleged that she was aware of it. However, the Second Amendment complaint was far bolstered in these facts. There's vastly more allegations about this, and what the allegations say is that Georgiana Slade, who is a trust and estates lawyer, was working closely with her father, and his father was 90 years old in poor health. She was fully aware that of all the interests. She was fully aware. She was involved most likely in the estate planning itself. She was fully aware of the interests and the fact that she and her sister were to receive those interests ultimately. And then there's a document that's in the record, it's not in the complaint, which was related to the transfer of that 5% profit share interest that shows the two trusts that the interests were provided to, and one of them is a Georgiana Slade trust. And so the complaint unquestionably alleges that she always knew and was aware, and then, in fact, during the course of this case, Jarvis died, and she, in fact, obtained those direct interests, and that was before, I believe, the second exercise of the power of appointment. And so, to answer your question, this complaint amply alleges that Georgiana Slade was aware of the conflicts. And the last thing I just want to say about this, Your Honor, is that the Rule 1.7 is clear that it isn't just a matter of your own financial interests. It's also the interests of your family, and so and personal interests, any other interest that would create a conflict. And there's no question that having tens of millions of dollars at stake is the kind of thing that a client would want to know about in judging whether their lawyer is providing advice that is free of a conflict of interest. Now, if Your Honor don't have any other question, I'd be happy to sit right now and then respond to.
We do have time on rebuttal. Thank you.
Good afternoon, Your Honors. Robert Hora of Millbank LLP, counsel for defendant respondents. This is actually PEC 4, not PEC 3.
Ah,
And
missed one?
yeah, there was, you probably may have forgotten about the defamation case against
Oh.
Lillian Peck, which I believe Your Honor was on that panel as well. It's time to end this. The trial court properly exercised its discretion in denying the motion to amend. This breach of fiduciary duty claim is founded on the
Can you address the allegation that your colleague, Ms. Slade, knew that she would benefit, that she would benefit from the proceedings in the estate because of the close relationship between her father and
Well, that is a wholly conclusory allegation in the complaint, and it's actually nothing new in this complaint. There was an equally conclusory allegation in the original complaint.
Well, she was aware of the fact that her father did have certain interests.
She was not. That allegation has been made. She testified in the record in the probate proceeding that she did not know about those interests at that time. And it's important to remember what this case is about at its core is...
Well, what about the notes? The fact that the estate representative did go forth with litigation as to the notes, although there, I think your friend points to a provision in the, a provision which talks about the notes and what actions are to be taken or not taken as to the notes.
And so I'm glad you raised the notes cases because that is at its core what this matter is about, and it was entirely proper for Miss Peck, Lillian, Ian Peck's stepmother, to pursue those cases. And Your Honors hit the nail on the head in terms of all my client did was represent Lillian. In fact, not actually in those notes cases, but the allegation that she somehow manipulated the filing of these notes cases is utterly conclusory and pled without any particularity. But those notes cases were perfectly proper to be filed. The notes resided in the estate. An executor has an undivided...
Is there an argument that it was a part of the estate plan that they wouldn't be litigated but would be a credit against various...
So there's a misreading of a provision in a trust, but what's important to note is at the time those cases were filed, these notes resided in the estate of Norman Peck. This was a pour-over will that would ultimately pour over into a trust, but there was litigation as to whether the will would be probated. So even if one credits that that provision in the trust instrument somehow offset the notes against Mr. Peck's inheritance, that wasn't a provision that was operative at the time the cases were filed, and indeed, a preliminary executor of an estate has an undivided duty of loyalty to the decedents to collect and preserve the estate's assets. Even if those notes flowed into the trust, they wouldn't be due to Ian until Lillian, his stepmother, passed away, because what this was a marital trust. So she was entitled to all income and discretionary principal distributions during her lifetime. And it's only after she passes away that Ian Peck is entitled to anything. So she was perfectly, even if the trust provision was operative, she was perfectly entitled to collect on those notes. And all my client did was represent her in the probate proceedings for a period of time. It was Farrell Fritz that represented her in the notes cases and was before this panel on that appeal in the notes cases. So this is essentially a case brought by a disgruntled beneficiary who did not receive effectively what he hoped to receive from his father. But that is not a claim against my clients.
Thank you.
Thank you.
Your Honor, I think what we heard from my colleague is a lot of disputing of facts. There are many things that he says. He calls allegations conclusory, and he disputes the interpretation of the trust agreement, trust document. These are all issues that are more properly decided after full discovery, and to be decided on a summary judgment or by a trier of fact. Just calling something conclusory is a facile way of disputing the facts, and that's what really needs to happen. Is there needs to be issue of fact. Now, the complaint adequately alleged that, strike that, sorry. The last comment that my colleague made was about the notes being enforceable while in the estate. And as I stated in the brief, the special master in the case, special referee, had found that the trust was a codicil to the will, and so that the language, the offset provision in the trust really had to be considered in connection with interpreting the will. And it would make no sense to say that if the trust provided for an offset that, well, you could still sue them anyway. It was clearly not the intent. And I think what this really comes down to is this court has already found that there were tribal issues of fact concerning whether the Norman's estate plan was violated. Okay, that issue, this complaint alleges that this was a result of conflicts of interest in which Milbank mislaid, pursued their own interests, their own sort of vindictive interest and interest in trying to get in out of these tens of millions of dollars of shared interest. The complaint sufficiently alleges these facts, and Milbank will have an opportunity to dispute these facts after discovery upon summary judgment trial. Thank you very much, Your Honors.